In the small town of Algona, Police Sergeant James Shrimpshire has been wrestling with a big problem.
Anytime there's a change in the law, people get nervous, especially when it deals with your profession.
He's talking about the consequences for officers who use deadly force, a nationwide debate that spawned I-940 in our state, a measure that would change officer accountability in such cases.
Put the knife down.
Our current state law says cops can only face prosecution if they exhibit malice in a deadly force situation. A Seattle Times study found that 213 people in our state were killed by police between 2005 and 2014, but only one officer was criminally charged.
There's always a concern that officers will be prosecuted.
Shrimpshire is the legislative chair for Washington's Fraternal Order of Police. At 2,700 members, one of our state's largest law enforcement labor groups. The FOP came out in opposition to I-940 in early December of 2017, saying it wouldn't improve public safety and would only make it easier to prosecute officers. But in March of 2018, just days before the end of the legislative session, polls showed a high probability I-940 would pass this fall, and Shrimpshire realized something had changed.
We're not too far apart.
The Fraternal Order switched gears and worked with community advocates and lawmakers to pass a series of new officer accountability measures by adopting I-940 and some companion legislation, House Bill 3003.
If that's some common ground that the community and us can come to is that reasonable officer standard, then we're doing the right thing.
Part of passing 3003 included an agreement that I-940 would not be on the ballot in November.
We were united and clear that there needed to be some change.
Lisa Dugard of De-Escalate Washington helped craft I-940. She says the campaign was prepared to go to voters this fall, but she was happy to make a deal with lawmakers and police.
We took yes for an answer. The opportunity to partner was one that we had never wanted to turn away from.
The agreed-upon standards would remove the need to prove malice to prosecute for the use of deadly force, would require more de-escalation training for officers, and would establish standards for the times when officers have to use first aid to help victims.
We did ultimately get to language that from the De-Escalate Washington side we felt strengthened the initiative.
But this effort towards reforming how officers use deadly force has just one problem, and his name is Tim Eyman.
Well, I really think that what the legislature did was unconstitutional.
The process looked like this. Lawmakers in Olympia approved I-940 as an initiative to the legislature, then passed House Bill 3003 to amend the language of the measure, as suggested by police and approved by 940's authors. No deal, says professional initiative sponsor Eyman, who's taking this case to court as a concerned taxpayer.
They adopted it as written, and then they changed it and refused to let the people vote on their change. You're not allowed to do that.
Our state constitution says the legislature has three options when presented with a validated initiative: approving the measure and putting it into law as written, taking no action, thus allowing the measure to go to a public vote, or proposing a different measure and allowing voters to decide between the two on the ballot.
It's a really dangerous precedent we're setting where the legislature is going to decide for the people how an initiative is going to become law. It doesn't work that way.
So I don't see this as a threat to the initiative process. The question really is just one of timing.
Dugard points out the legislature did adopt 940 as written and had the right to make changes to it via House Bill 3003. Changes that would kick in a day after 940 legally goes into effect in June. Tim Eyman disagrees.
The sponsors of initiatives do not speak on behalf of the 360,000 people who signed the petition.
Eyman will have his day in court, with the aim of making sure both I-940 and the legislature's revised version are on the ballot this fall.
I think we're all united around the realization that this sort of elaborated version of 940 is a really good place to be.
Dugard says De-Escalate Washington will go through whatever legal process necessary to turn their negotiations with legislators and police agencies into law. Editorial boards around the state agree with Eyman, which could portend delays and more complications for an urgent nationwide debate over the need to change deadly force policy.
Do the right thing. This is the right thing to do to bring the community together.